Hi friend, welcome to the company law procedural video series. Today we are discussing a procedure for the alteration or changing of the object clause of the memorandum of association of the company. Here we see what are the legal provision and what are the procedure and what are the draft resolution language. Dear friend, first we understand why what are the alteration or changing in the object clause, why it's needed. When we start something new business, some new business in with existing business, or we are shifting from one business to another business and exploring something new and modifying some business line, then alteration of the object clause is required. This means alteration. What we understand by alteration? Alteration means adding, deleting, modifying, substituting, or we adopt combination of the method: addition, deletion, modification, substitution in the object clause. That's why that is the alteration or changing of the object clause. Let's see first what are the legal provision for the changing of the object clause of the memorandum. Here we specific that the object clause is changed by a special resolution and complying with the procedure specified in section 13 of the Companies Act. And a company shall, in relation to any alteration of its memorandum, including object clause, file with the registrar a special resolution passed by the company, and registrar shall register any alteration of the memorandum with respect to the object of the company and certify registration within a period of 30 days from the date of the filing of the special resolution. And subsection 10 says no alteration made under this section shall have any effect unless it has been registered in accordance with the provision of this section. These are legal requirement for the alteration of the memorandum, that is the changes of the object clause. And let's see what are the procedure involved for the alteration or changing of the object clause. Here is the step by procedure. First, issue notice in writing to every company for holding a board meeting. So before holding board meeting, you initiate notice, issue notice to every director, and the notice should be 7-day notice. That's per requirement of section 173. And notice must contain date, time and venue of the meeting and detailed agenda of the business, notes to agenda and draft resolution. Check Secretariat Standard 1 for this requirement. Section 173 says what are the legal requirement for issuing of the notice. Secretariat Standard 1 says for the board meeting, this Secretariat Standard for the board meeting. So here the notice should be properly content and proper time period, at least 7 days notice should be given in writing to every director at his registered address, and notice contain time, date and venue of the meeting, detailed agenda of the business, notes to the agenda and draft resolution, and then hold a board meeting at the appointed time, date and venue. And in the board meeting, consider and pass resolution approving the proposed amendment to the object clause. Consider and pass another resolution fixing time, date, and venue for the holding general meeting, because a special resolution is required, and a special resolution passed in the general meeting and of the company, and passing a special resolution under section 13 of the Act for change of the object clause of the MOA, and approve notice of the general meeting and draft resolution with explanatory statement annexed to the notice of general meeting, and authorize the company secretary or other competent officer to issue notice of the general meeting. These are the resolution should be passed in the board meeting. After holding board meeting, issue notice of the general meeting to all the members of the company, its directors and auditors. Here a proper 21 clear days notice should be issued, and hold the general meeting at the appointed date, check the quorum before the meeting, starting meeting, check whether auditor is present. If not, then leave of absence is granted or not, and pass the proposed special resolution and approval of the alteration in the MOA. Approval of alteration in the MOA. These are the points check in the general meeting. And after holding general meeting, if resolution pass, then file with the ROC form MGT 14 along with the certified copy of the special resolution passed by the company with copy of the explanatory statement annexed to the notice of the meeting and amended copy of the MOA attached to the form within 30 days of the passing of the resolution. That is the registration of your special resolution. And registrar shall then register the alteration and issue a certificate. This certificate will be conclusive evidence that all requirement with respect to the alteration duly complied, and the alteration should be complete and effective on the issue of the certificate. And after certificate is issued, amend each copy of the memorandum available in the office, or alternatively fresh copy of the memorandum to be got printed. These are the step by procedure for changing or altering the object clause of the company. And for the listed company, there is some other requirement. Send copy of the notice to each stock exchange where the securities are listed within 24 hours of the occurrence of event or about alteration of the memorandum and articles within 24 of the occurrence of event, and copy of the each proceeding for the general meeting intimated to the stock exchanges within 24 hours of the occurrence of the event. These are the listing requirement applicable on the listed company. And now see what is the language of the draft resolution and the object clause of the company. If you needed a draft resolution, you may email or WhatsApp on my number. Then we'll forward you a draft resolution copy. First, in board meeting, there's a draft resolution language. You draft language as the resolve that pursuant to the provision of section 13 and other applicable provision, if any, of the Companies Act 2013, including any statutory modification or reenactment thereof for the time being forth, and the rules framed thereunder, consent of the board of directors of the company be and is hereby accorded. Here, subject to the approval of the ROC. If ROC approval is not granted, then your registration is approval is not valid. So subject to the approval of the ROC, name of the ROC, where Jharkhand, Delhi, whatever jurisdiction follow your company register office, and subject to the approval of the shareholder in the general meeting, to amend following sub clause 3. Write a specific clause 3 for whatever the applicable. If you are including inserting something, then write language. You are deleting something, so write that language and modification accordingly. And after sub clause 2 of the clause 3A of the MOA, to write to carry on the business of the inserting something, you're modifying something, to write language in substituting this clause and you. And further resolved that authorize some person for the purpose of the giving effect to the resolution, Mr. ABC, director of the company B, and his share authorized on behalf of the company to do all acts, deeds, matters, and things as deemed necessary, proper, or desirable, and to sign and execute all necessary documents, application, and return for the purpose of the giving effect to the aforesaid resolution, along with the filing of necessary inform with the registrar of the companies. You may modify language as per applicability, as per applicability. You are adding something, deleting something, modifying something, substituting something. Accordingly, you change the language. And now see what are the draft language of the shareholder resolution, passing a special resolution. That's why here is given a draft resolution copy. Resolve that pursuant to the provision of section 13 and other applicable provisions, if any of the Companies Act 2013, including any statutory modification or reenactment thereof for the time in force and the rules framed thereunder, consent of the shareholder of the company be and is hereby accorded, subject to the approval of the registrar of the company, to amend following clause, same language, to carry on the business of. Here we are inserting. And further resolve that for the purpose of giving effect to the resolution, Mr. XYZ, director of the company, be and is hereby authorized on behalf of the company to do all its deeds, matters, and things as they deem necessary, proper, or desirable, and to sign and execute all necessary document, application, and return for the purpose of the giving effect to the aforesaid resolution, along with the filing of the necessary e-form with the registrar of the companies. This here is a draft resolution. If you need this draft resolution, you may email or WhatsApp, or give your number in number or WhatsApp number or email ID in the comments box. We will provide you. Thank you so much for watching this update. In case you have any need query regarding this change of the object clause and need assistance, then you may contact on the given number. Thank you so much.